Okay, well, thank you everyone for joining what is actually our first event for the White Collar Associates that's firm-wide. I just wanted to introduce, before I introduce our panelists today, what the event is and what the group is. So we have started a White Collar Associates group, Sarah Clark and myself, and the idea behind it is for people who work in white collar and for people who are interested in white collar practice at the firm. We want to be able to serve as a resource to you. And also we have a listserv, an email that we started earlier this summer where people can send out more specific requests, and hopefully we'll be sending some helpful information on that listserv as the group grows. But part of the idea was to do a remote event across offices that would be of interest to people. And so for the very first event, we're doing one focused on SEC practice work and lessons in litigating SEC practice. So as part of that, I have joining me, of course, Michael Liftik, who's the co-chair of the firm's SEC enforcement practice, and Marc Fagel, who, full disclosure, is my cousin. So I'm very glad to have Marc with us today. I wanted to give a little bit of a bio and background as to both Michael and Marc before we get into the questions. So Marc Fagel spent over 15 years with the SEC's San Francisco regional office. He served as the regional director from 2008 to 2013 and led the SEC's enforcement and examination programs for Northern California and the Pacific Northwest. He previously served as associate regional director in charge of enforcement, where he oversaw investigations ranging from public company reporting to insider trading to misconduct by regulated entities. And Marc has helmed some of the largest securities fraud cases that have ever been filed in the Pacific Northwest. After leaving the SEC, Marc was a partner at Gibson Dunn, and he's currently a lecturer at Stanford Law and also serves as an expert witness in SEC practices. And then Michael, of course, people at the firm know you. I haven't had the opportunity to work with you yet, but I will give a little bit of background on Michael, who served as the Deputy Chief of Staff of the SEC, where he served as a senior legal advisor on all aspects of the SEC's operations. Before serving as Deputy Chief of Staff, he was the senior advisor on enforcement and also counsel to the director of the Division of Enforcement. And Michael began his career at the SEC in San Francisco as an enforcement division staff attorney, where he and Marc met. While there, he investigated and litigated a wide range of securities law violations, including FCPA, insider trading, financial and accounting fraud, and complex offering frauds. So thank you, Michael and Marc, for both joining me today.
Thank you. Thanks for hosting.
So first, I just wanted to ask how each of you ended up getting involved in SEC work. And this is before you joined the government, because we'll get to that. But Marc, when you, after you graduated University of Chicago Law School and you were working at Morrison & Foerster as an associate, what drew you to this line of work before you ended up actually going to the SEC?
Yeah, and I wish I could say something drew me to it and that there was some intentionality. It's much less fun. I got to MoFo after graduating law school, and the first day I walked in, they said, "We have a securities class action and you are on it." So that was it. And then I enjoyed doing the work, and like a lot of young associates, was then in the position after that first case of, do I become more of a generalist, try other things out, or now that I've learned something about securities law and securities litigation, do I stick with it and try to become more of an expert and really hone that practice? And I mostly went in that direction. So I continued to do securities class action defense work, and got to work on some SEC investigations. And those were a lot of fun. We can talk about that later. I really enjoyed the SEC investigation defense. And then as some friends of mine from the defense world moved over to the SEC side, when an opening came up and they said, you should come over to the SEC. This is a great job. I had been at the firm about 6 years and was ready for something different, and it was just a great opportunity.
And then Michael, after you graduated Harvard Law School and when you were working as an associate, what either drew you to SEC work, or did you automatically kind of shoot into it?
Yeah, I think similar to Marc, it was happenstance. I clerked for a couple of years, and then I joined a firm, and the first big case I was on was what we came to call market timing case, which ended up being one of the big financial scandals that this was around 2002 that sort of has happened over the last 20 or so years. And I just got thrown on this case. It was actually an SEC investigation, but it was so urgent that the SEC unusually skipped their investigation and actually went right to litigating because they had gotten outflanked by a state attorney general who brought the first case. And we were involved in the very first one. And so it was exciting. It was novel. And the partners that I were working for, who were used to doing SEC work, were, just apoplectic at the process. And I'd never done it before, so I didn't know one way or the other. But it was really interesting. It was fast paced. It was exciting. It was in the papers. And then the next case I got on was, we were suing a big venture capital firm. So I continued to learn more about sort of the securities industry, got put on a securities class action or two. And then it just kind of kept coming back. I did do other work. I did a little bit of real estate litigation. I did telecom litigation. But the cases I enjoyed the most kept being these securities cases and SEC cases. And I moved out to San Francisco after a couple of years and got put on some pretty big SEC investigations. Actually, when Marc was in the office, and I was an associate in San Francisco, and got to learn the other side of the defense side of things. And it just kind of kept coming back to the work I enjoyed.
And then how did each of you end up working at the SEC? And I'd like to hear, because I'm curious from my background of leaving a big firm, going to government work, and then coming back to the same big firm, what the benefits are of, working for the government, working at the SEC as part of your larger career trajectory.
So for me, as I said, I had become something of an SEC and securities law specialist. And so some of my peers had actually gone to start working for the SEC. And when an opening came up, they let me know. And it was good timing for me. I was a sixth-year associate at the time. So I was at that point of, do I pivot to partnership track and really bear down, or do I try something else? And the way it was described to me, and unfortunately it panned out, is I got a lot of training opportunity at the SEC that I was not getting as a senior law firm associate. And that's hit and miss. And I have no complaints. I was getting some pretty good work at the firm, but it doesn't compare to the level of responsibility that the SEC offers from day one. And one story I tell on the difference is, one of the first investigations I did after going to the SEC, the defense counsel was my old firm, was Morrison & Foerster. So I was, as a first-year staff attorney at the SEC one day, taking sworn testimony from the CEO of a public company, which was, pretty cool opportunity for someone at my age. And across the table from me, representing him, was the partner I used to work for, my old boss. And sitting next to him was an associate who was a peer of mine, same year in law school. And she was basically handing him documents. So it was a marked difference in the amount of responsibility I was given right away. So that was a big draw. And I always saw it as sort of a revolving door. I had no intention of staying very long. When I went to the SEC, they made me commit to 3 years. And I said, okay, 3 years sounds about right. I figured I'd do it for a few years, get a lot of hands-on experience, and then go back to the defense bar, which I really did enjoy. And then that 3 years, I enjoyed it. I had more and more opportunities. I was able to move through the ranks. I ended up staying there almost 16 years before pivoting back to the defense bar. So it was partly just the responsibility, the hands-on work. No secret, there's a lifestyle difference. We were starting a family at the time. The hours of big law, I don't have to tell anyone who's listening right now, are very demanding. And the government is not a 9-to-5 job, especially if you want to succeed. So no illusions about that. But it's certainly more manageable than big law. There's obviously a trade-off in pay. So you have to decide what works for you in your lifestyle and your family situation. But for me, to be able to cut back a little bit on my hours and the stress levels and do something I really enjoyed was great as my kids grew up. And then as they were out of the house, then I was ready to say, okay, I'm ready to go back to the defense side and bear down. So it worked very well in that way.
Yeah, pretty similar story. I was doing a lot of SEC work, both the investigation, defense, and actually litigation, because at that time there was sort of, we were on to the next scandal from market timing. The next scandal was stock option backdating, at least out in Silicon Valley. And that's what everybody was working on, was keeping Marc and his colleagues at the SEC at the time incredibly busy. It was keeping the defense bar incredibly busy. And I was a 4th or 5th year associate at the time, maybe 6th year. I remember sort of very distinctly the moment where I said, I think I want to switch sides, because I was in a deposition. We represented the CFO in one of these stock option backdating cases, and he was actually sort of a nice guy. And they were taking the deposition of the CEO in one of these cases, who was distinctly not a nice guy. And you had sort of the typical, big slate of lawyers on one side of the table. It was, the lawyer and then 5 people. And then, we were sort of way down at the other end of the table, but it wasn't just me. There were like 3 other people from my firm there. And way at the end of the table, you had to almost take out binoculars to see her, because the table was a staff attorney who was clearly roughly my age and seniority, and was just taking this deposition of the CEO, opposed from some of the most senior members of the SEC defense bar, who were doing everything they could to give her a hard time. And quite frankly, she was unflappable. She was just sitting there doing her job, asking her questions, working her way through the documents, getting, good stuff after good stuff. And I said, you know what? I think she's having a lot more fun than I am. And so I said, I want to go do that. And likewise, I mean, I think actually, it's obviously sort of a statement against interest for all of you who, work on my cases, but it's, I'm never going to tell you that working for the government is a bad idea. It really is a great idea. Obviously at Quinn, we try to give people a lot more hands-on experience. So I think my experience as a 4th or 5th year at that firm is probably different from your experience as a 4th or 5th year. But still, I agree with Marc. You're just going to get an incredible level of responsibility and experience. And so I applied to the San Francisco office and somehow convinced Marc, and at the time he was running the enforcement group, and convinced him that he should bring me on. And then, I got over there, and it was a lot more fun being on the other side of the table, being the one asking the questions. And you get an incredible amount of responsibility. It's one of the things that Marc explained is, if you're taking the testimony from the CEO or the CFO, the most senior people at the company, unlike in private practice where the partner is going to come and be like, I'll handle that. That doesn't happen at the SEC. You might have a supervisor there next to you to sort of guide you and help you, but you're going to be the one working up the outline, working up the documents, all the things you're used to doing. But then you get to ask all the questions. It's your testimony and it's your investigation. And that's fun.
So, Michael, one thing that you mentioned the other day when we were talking about this session was that one reason you really liked SEC work was the Wall Street Journal is basically a paper that cover to cover covers everything that you all do, because SEC work essentially covers all of the topics that are driving the national dialogue at the moment, which as a former reporter, I found that really interesting and intriguing, that that's what SEC work is, and kind of demystified it for me. So I wanted to talk about kind of the topics that are driving that national dialogue right now. So I wanted to run through a few of them. The first one top of mind is cryptocurrency. Of course, that's what everyone's talking about and what most of the SEC action work is about right now. So I wanted to ask both of you, Marc and Michael, your perspective on how the SEC is handling cryptocurrency, whether it's doing the right thing or the wrong thing, and get your perspectives.
Michael, I'm curious to hear from you.
Yeah, so I'd say about 50% of my practice is crypto these days. It's completely unintentional. It's just those are the cases that the SEC is bringing. What I tell people is, when I was working for the chair of the agency in 2013, that is basically when the SEC sort of started scratching its head and saying, what is this Bitcoin we're hearing so much about? And so we brought together, when I was there at the time, we brought together sort of an intra-divisional group that was going to study it, try to think about it, try to figure out what it was. And we sort of very quickly realized, well, okay, there's more than Bitcoin. There's a few other tokens out there. And what really matters are these digital ledgers that people are talking about. So that group kind of expanded. into sort of studying digital ledger technology. But the decision, and I don't think this is really anything non-public, but the decision at the time, 2013, 2014, 2015, was to really be incremental and let these technologies develop. It wasn't abundantly clear that there really even was a securities law issue unless you're running sort of some kind of scam. And there were, I think 2015, there was the first, they call it the first Bitcoin case, but it wasn't anything about Bitcoin. What the guy was doing is he was saying, I'm selling you Bitcoin, but he wasn't. He was just taking your money. And so you didn't really need to find that Bitcoin was a security. It was just a good old fashioned, offering fraud. And the SEC is always going to do those cases. And that's sort of where things were when I left the agency in 2017. And when Chairman Clayton came in, I think he pivoted hard to crypto, and for some, I think sort of for some good reason. There was what they call a boon of ICOs, initial coin offerings, which was really a dumb name that the industry picked because it was almost like poking the SEC in the eye. They could have called it something else, and they might not even have noticed. But my perspective today, and obviously then it's just more and more and more. My perspective is the SEC is, quite frankly, I think they've sort of lost their way a little bit. I think that they have had years now to put some rules out there, to put some framework out there. It's almost a weird sort of dogmatic stubbornness to say we don't need rules. We have this one Supreme Court case from 1946 that tells you whether it's a security or not, and I think that test just it sort of works, but it doesn't really work. And the SEC has the authority to put more flesh on the bones and to have a sort of thoughtful approach to this new asset class. What I always say is like, look, no one's ever going to object to going after the fraudsters and the bad guys who are scamming people. But people look at things like FTX and they say, oh my God, FTX blew up. See, it shows you that crypto is a scam. I don't think so. I don't think FTX is any different than Madoff or Stanford or any of these other big kind of Ponzi schemes, without sort of prejudging whatever may or may not have happened there. But in other words, there's always going to be people who are pulling off frauds, and whether that's in crypto or traditional securities or what do they call those? The chain emails. Please click here and I'll send you $1 million. Those are always out there, but the asset class has some real potential. And I think the SEC over the years could have been more thoughtful about it. And now we're in a situation where they really do. I mean, the phrase is regulation by enforcement. I think that phrase gets overused. But I think that's actually what they're doing in crypto. They're really, that if you want to know the current state of affairs for crypto, you have to read all the enforcement cases and say, well, here's what they think. Now the case law is starting to develop, and we're starting to get to sort of a little bit more of a traditional legal framework, because enough cases have started to work their way through that you can say, well, under the Ripple case, this might be okay, and under the Terraform case, that might not be okay, and there's Telegram, and there's Kik, and there's a few other important cases out there. So it's getting a little bit better, but that's quite not because of the SEC. I mean, it's because they brought cases that defendants chose to challenge.
Yeah, I tend to agree with most of what you say. I have a dimmer view of crypto. I do tend to think there is a large scam element to it, not necessarily to the technology of the blockchain, for which there are, or at least at some point could be use cases. I do think it's problematic. That said, I think you're absolutely right. I'm in agreement that the SEC has not done the best job a regulator could do here. I think it does expose the biggest limitation that anyone who's worked on either side of SEC cases, which is that the agency is ridiculously slow. It's slow with enforcement, it's slow with policy and rulemaking. And I remember, even as one of my roles as regional director was try to work the bureaucracy and help my staff get cases through. And I remember distinctly Michael, especially because, as anyone who knows Mr. Liftik can confirm, is an aggressive lawyer who wants things to happen and happen efficiently and effectively. And Michael and others would be in my office like, can't we make this happen more quickly? And despite my best intentions, it was always a struggle, because eventually you're getting into Washington, D.C., and there are 5 commissioners who have to vote on everything and multiple levels before you can get in front of them. And I think with crypto, that's what happened. I think, Michael and others were doing the right thing. I had left the SEC by the time crypto became a thing, and I was on the defense side representing crypto. But I think it was the right thing to take a slow, studied approach. But I think at some point you have to pivot when you realize there's an issue, and the SEC was slow to do that. So when you do have FTX and Luna and Genesis and so many implosions within a year or two, at that time, it's too late for the SEC to be more proactive. At that time, the only tool it has to move quickly is to start suing everybody. And the law is not where it needs to be. The SEC has had some success, but then you have a case like Ripple a few weeks ago, which did not go the SEC's way in large part. They're relying on the courts giving them a wider berth than the law may allow. And that's because they did not move more quickly to regulate this growing problem. It's easy from the outside to poke fingers and say, why didn't you move more quickly? But it does illustrate that it's a reactive agency. And Michael had mentioned the first thing he worked on the defense side, market timing, and that you're absolutely right. I was there. We did market timing cases, but only after the New York Attorney General embarrassed the SEC by bringing a case that the SEC sat on. So it's not a new phenomenon for the federal government to be a little behind and then have to scramble to make up for lost time.
So in terms of like being behind and maybe trying to figure out what the next big frontier is and whether the SEC should pivot for that, AI or artificial intelligence is of course another big topic that everyone's talking about. Do you think that the SEC will learn from maybe mistakes and going too slowly to react to cryptocurrency and change its approach when it comes to AI, or how the SEC will handle AI?
Michael, what do you think?
Yeah, I mean, I think that's a good question. Will they learn their lesson? I mean, probably not, as Marc says. I mean, this is sort of like a story that gets told over and over and over again. But I think I saw in the news actually just the other day that there's a report that the SEC is doing a sweep of AI with private fund advisors. And that basically means hedge funds, private equity funds, mostly probably hedge funds that are engaged in various investment strategies. And obviously computerized trading and algorithms, that's been around for a while, but now do you have AI, particularly as you think about investment advisors that are looking at your financial profile and trying to predict how you would like to invest, or taking a hedge fund strategy and not just applying, a brute force algorithm, but, sort of trying to pick up trends from the news and things like that and invest. And it looks like the SEC is doing a sweep there. So again, they're starting off with, enforcement or maybe exam, because that's how they can kind of get into firms quickly. The question will become, is this an area that needs regulation? And I think Gary Gensler, who's the chair, has started to, starting to say things about needing regulation. But I think AI is one of these areas where it's certainly much bigger than the SEC, and you don't think that the financial regulator, the markets regulator, is really where this should start. I mean, a lot of the issues with AI are bigger and touch other areas, and that's actually, quite frankly, like that's where the government is at its weakest, right? If you have to sort of have cross-agency cooperation and a holistic government solution, that's really hard because all the different agencies, and I worked with a lot of different agencies, and you get to see how they work, and they all work differently, and they all have sort of different views of things. And the SEC can be slow, but it's not like the other ones are moving quickly either. So I think it's a real challenge.
Yeah, I'm with you there. And again, it's encouraging to see them using the tools that they do have quickly, getting out ahead of it, talking about it publicly, getting on top of the industry. Can they predict? Part of the problem that you have is, while a lot of us do go through the revolving door, like Michael and I, and the leadership turns over all the time, even so, a lot of the line level staff are there for a long time. So you don't necessarily have the fresh blood, to know the issue. So, there are people at the SEC who recognize that there are risks to investors from the use of artificial intelligence. They don't necessarily have somebody who is actually at a hedge fund right now jumping over the fence to go work for there to know what the industry is doing. Again, they tend to be reactive. It's only after something goes horrible that they can start using enforcement. So that's, the most likely scenario. And sometimes people just need to be realistic that, yes, there are a lot of regulations the SEC promulgates that do an amazing job of protecting investors. But for something that's an emerging issue that's moving quickly, rulemaking is not designed for that. And when the SEC does try to move quickly, I guarantee you that my old law firm, Eugene Scalia and other appellate lawyers out at Gibson Dunn and other politically connected firms in DC will sue the SEC the day after they promulgate a new rule saying you moved too quickly or too slowly, you did something wrong. The DC Court of Appeals tends to go against the SEC on that. So, the rules don't get passed, and then it does fall ours land enforcement to say, well, we're going to use the existing laws to sue people, which may be too late for investors to get their money back, but at least it gets the word out. And, it's a cynical way of looking at things, but that's how it tends to go.
And now, Marc, I'll turn to you next for the next topic, because I know when we were talking about this webinar, ESG was something you brought up as another big frontier or something with regard to SEC practice. So tell me a little bit about that.
Yeah, it's a fun one. It does show how politicized this can get. The norm is that the SEC's work is not usually politicized. Most commission votes are 5-0, whether for rulemaking or enforcement. With someone breaking the law, everyone's on board. ESG is pretty divisive. There are those who think that companies do have an obligation. ESG means environmental, social governance. Should companies be more mindful of their anti-discrimination policies, more mindful of what their product, their business does to the environment, and disclose to investors? So investors can say, I don't care whether or not this is a good financial investment. I don't want to give you my money if you are doing bad things to the environment. For a lot of people, that's laudatory, and the SEC should make sure that companies are telling investors about that. Some people take a very different view and say, investments and companies that manage investments should be about maximizing profits. And it's not the SEC's job to tell people, to worry about discrimination and climate change. So that gets very politicized along, predictable grounds. The SEC has been doing a lot, primarily with investment managers. Those investment managers who are telling their investors, we are going to invest in a way that is ESG conscious. The SEC wants to make sure you're not just using that as a tagline, you're actually living up to that. So the SEC has been enforcing that. But from a go forward basis, is the SEC going to do more than say, it's one thing to say, we want you to disclose your ESG related policies. It's another thing for the SEC to substantively say, we want you to meet certain targets. That's much more controversial, and I think will limit, the SEC is not going to have as much ability to do that.
Yeah, I think that's right. It's a challenging area for the SEC because the politics are so kind of dialed up to 11 on that. I was actually talking to a law school classmate of mine who's now in Congress. He's a Democrat. He's been in Congress for a while now, and he's on the House Oversight Committee. And he calls me from time to time just to sort of like, hey, what's this issue all about? And so he actually called to ask. He's like, well, ESG. He says on House Government Committee, we jokingly on the Democratic side we call it the Hunter Biden Committee because every other word out of the Republicans' mouth is Hunter Biden this, Hunter Biden that. And they say, but if they're not talking about Hunter Biden, they're talking about ESG. And he says, like, is this like a threat to the country? Like, what is this? And so we kind of walked through what the SEC is doing, and that there are sort of those two components that Marc mentioned. And I think it's really interesting. The idea that if you're advertising a hedge fund or a mutual fund as being green or being ESG focused, good old sort of truth in advertising rules should apply. And why not take a close look at that? If you're telling people your investment strategy is going to have certain components to it, shouldn't you be accurate about that? And so that seems totally fair for the SEC to be looking at. And yet, because it's ESG, it's somehow controversial, where if I told you I was running a technology fund and all I was doing was investing in sneakers, you'd say, well, that's not a technology fund. You're clearly misleading investors, and nobody would think twice about bringing cases like that. Then, as Marc said, on the more prescriptive, that the SEC has a proposal on a climate change disclosure, where the SEC, the rule would say, no matter what kind of company you are, if you're a public company, you have to disclose certain things about your impact on climate change. Now, that's a bit more challenging because, as Marc was alluding to earlier, the SEC has a lot of great people. That the agency is run by its professional staff. There's only 5 politicals at the SEC, which is actually different than a lot of agencies. It makes it really nice and fairly apolitical, that the staff is sort of a professional staff, but they're mostly lawyers. There's some accountants, a couple economists. There are no climate scientists. And so the idea that the SEC is going to kind of come up with how much, I think they broke it down into 3 tiers, and it's like, well, I run a factory, so my emissions are X. Then I got to think about, well, where do I put the things that I run in my factory? And then what about the UPS trucks that deliver stuff to the factory? Those are very tricky policy judgments. And I thought it was interesting that the SEC went there, having lived through some of the more challenging rulemakings that Congress told it to do, coming out of yet another financial crisis from 2007 and 2008. There was a law passed called Dodd-Frank, and there were a lot of rulemakings that the SEC had to do. And one of them was called conflict minerals. And the idea was Congress said, you have to pass a rule, SEC, that makes public companies disclose to what extent their products implicate these conflict minerals, which is, lithium mined in the Congo or things like that. There was, a movie, I forget what the movie was called, which was about blood diamonds. Maybe it was called Blood Diamond. I don't remember. But, there was sort of in the news about, people not knowing about the horrible working conditions in Africa and other exotic places where some of these, minerals, like in your iPhone, there's all this stuff in it. And it was really challenging for the agency because they didn't have mineralogists or geologists or, even geopoliticians to, sort of figure out, well, how do we pass this rule? Like, what are the right percentages, and what are conflict minerals, and what countries are okay and not okay? They really struggled, and they would pass the rule and get struck down by the DC Circuit, and they try to pass the rule and get struck down by the DC Circuit. And eventually the agency kind of threw up its hands and was like, they can't really do this, but because Congress gave them a mandatory rule, but they kind of pocket vetoed it and be like, oh yeah, we're working on it. And what ended up happening is then they got sued by the other side saying, you're not passing this rule. Congress told you to pass this rule. And they're like, we are trying to pass this rule, but we don't know what we're doing. So I think that's sort of a lesson learned in trying to take on substantive areas where, the SEC doesn't necessarily have the expertise to do it. And I think climate is that area. It'll be interesting to see what they do. So that's my shtick on ESG.
Well, I want to pivot a little bit to, because our audience, and we're recording this as well, are largely going to be associates who either already work in SEC practice or are interested in it, but do largely civil litigation. So I want to hear both of your takes on how working in civil litigation is different from SEC practice, and kind of lessons learned there of how you might treat that practice differently. So Marc, I'll start with you.
Sure, and that's probably one of my favorite things about doing SEC enforcement work, both with the SEC and on the defense side. I was a litigator all my life, and the thing I hated most was the FRCP part of it, the federal rules part of litigation, the interrogatories, the motion practice. I like learning the facts and going through the witnesses and getting to the bottom of things. And that's what enforcement is. Enforcement is really everything leading up to the first day of litigation. And if you're an SEC attorney, you then, if you file a case, you live with it once it goes into federal litigation, and then you're, working around the federal rules. But most of investigations happen before that. And then you're still having to read documents. And as an associate, it's no fun sitting in front of a database and reading a million emails, but you're really in the weeds of the facts. You're reading the documents, you're interviewing the witnesses, you're trying to decide for both sides, whether you're the SEC or the defense, what happened here, who's responsible, what are the remedies that are appropriate to resolve this and make sure it doesn't happen again. And that's the fun part of it. That's, figuring out the truth. That's like getting to be a detective, getting to be a litigator without, all right, we've got to file a motion to dismiss, and then we're going to have an amendment, and then we're going to start discovery, and we're going to haggle over discovery. None of that really happens in enforcement until you get into enforcement and until it's filed as an enforcement action. So that's my favorite part of it. That's what makes it interesting to me. And then the other part is, and Michael can talk about this as well. For those of you who have not done SEC enforcement actions, the politics, the interpersonal politics are very different than litigation. It's much less adversarial. There are arguments about the scope of document productions and making witnesses available, but it is much more amicable, partly because if you are defense counsel representing someone before the SEC, the way you conduct yourself and the way you show your client to be what sort of person or company they are will influence greatly what the SEC ultimately does at the end of the investigation. So there's a real interest in working together, trying to get to the bottom of things, and a lot less fighting. And people who like that part of litigation, the arguing and so forth, there is room for that. That happens, especially once it goes into litigation. But for the most part, when you're taking testimony at the SEC or defending testimony at the SEC, you don't have objections, or they're minimal objections. You're not getting, we need to create the record that we've raised this objection for hearsay and so forth. It's really about getting to the truth. And that's much more enjoyable. It's less stressful. And at the end of the day, you go home and you feel better on either side. Like, okay, we've gotten a little closer to getting to the bottom of this, as opposed to, I spent the last 24 hours writing interrogatory responses. So that was always my favorite part of the job.
Yeah, I agree. I remember, again, one of the moments where I was like, I'm not sure I want to do this forever is I was, before I went to the SEC, I was doing a securities class action, and we were having all these meet and confers over documents and requests. And we would have these meet and confers, and I was ostensibly running the meet and confer, but the junior partner, I was an associate at the time, would sort of be in my office. Remember offices? We used to go to offices, and he would stand over my shoulder, and I'd be sort of having this dialogue. And the junior partner couldn't help himself. He would just launch into the other side, start screaming at the guy. The other guy loved it. I mean, he'd start screaming back, and I'm just like eating popcorn, being like, this is ridiculous. Like, these are two adults and they're screaming at each other over like whether some piece of paper is going to go from one side of, the city to the other side of the city. And you don't have that I mean, you can get contentious, obviously, but the approach is totally different. Starting with document productions, which is obviously really important. And those of you, I don't know if anyone on has worked with me on an investigation, but, unlike in civil litigation where it's like, let's finally parse this request and figure out how not to produce stuff. Your goal in an SEC production is to, sort of fairly read the requests almost in the government's favor and say, okay, well, it's on the line, but we should probably give that to them. And the reason is because, as Marc said, the whole dynamic is different. Yes, it's adversarial, but it's a much sort of quieter adversarial. It's being a good advocate. And you're going to win on the facts. You're going to win on the facts. You're going to win on the law, not on whether or not you give the documents. If you have a bad document and it sort of is called for, you give it over, and your job is to explain why, there is no violation, or it's the SEC's job to say, haha, we have our smoking gun and you guys are toast. So let's talk about a fair settlement over that document, not haha, I figured out a way to read the request in a way that you don't get it. Because ultimately, if the government finds out that you're hiding things, it's the old, like, cover up is worse than the crime. Like, then the whole thing falls apart, and you're going to be in a lot of trouble, maybe not just with the SEC, but with the guys who carry bracelets. And so you have to be very careful, as you're producing things. The other thing that I think is really fun, kind of, again, sort of on both sides, but particularly on this side, is when I was when I just started at the SEC in the San Francisco office, one of the staff attorneys who'd been there a long time said to me, the most power that an SEC staff attorney has is not bringing a case, but it's closing a case. Because if you want to bring a case, it is really hard. You have to convince, your boss and your boss, and then you got to go to Marc and you got to convince him that it's a case. And then you got to deal with DC, and like 14 different divisions have to sign off on it. And then you have to convince the presidential appointees to bring a case. It's very hard and it's very time consuming. But if you as a staff attorney get to the conclusion, like, we don't actually think there's anything here, let's close this down, it's pretty much you and your supervisor agreeing to that. And then you kind of sell it to your boss and they go, okay, fine, shut it down. And so I always keep that in mind on the defense side, because what it means is you should always be thinking about, is there a way to shortcut this process? And that's something that we do a lot in our practice. Is we don't just respond to the document requests. We dig into the facts really fast and really deeply and say, is there a way to say, look, we think we know what you're looking at. but you don't need to worry about it. And here's why. Let us come in and give you a presentation. And we have shut down a bunch of cases using that strategy. And what's nice about it is the staff is open to that. That's part of how an investigation works. It's not like, litigation, once you're in discovery, you're in discovery until you get to summary judgment. You can't say like, look, we've all looked at the documents. We know we win on summary judgment. Can't we just kind of agree like, no, that you could settle the case, but you're not going to sort of, win on the merits until you get to that step. Whereas in an SEC case, if you can sort of show to the staff, like, I get that you open an investigation, but there's really nothing here. They're happy to hear it and move on to a case where there is a case instead of spending 2 years investigating. And so it gives you opportunities to, I think, kind of not only think creatively, but get to know the facts really quickly and then get to an advocacy stage. And again, the other thing that we do is one thing I will say is I think sometimes people think that government work doesn't lead to the same kind of hands-on opportunities that civil litigation does. And while that's, I think, true to some extent, if you're doing SEC work, you're always defending testimony. You're never taking. You don't get to take testimony of the SEC. You're just always defending, and that typically has to be sort of partner driven because it's pretty high stakes. But obviously you have second chairs, just like you have second chair defending a depot. But we do look for opportunities for associates to do parts of presentations. If you're making a presentation to the staff, carving out pieces, and that's akin in my mind. And I tell folks who are working in the practice, that's like doing an argument in front of a court. You're responsible for it. You're responsible for everything that's said. Sure, we're there. We're listening. We're going to back you up if thing goes sideways. You get a really hard question that requires, sort of goes beyond. But there are opportunities for you to really test your skills and kind of go toe to toe in a way where, the staff could sort of just start asking you questions. And all of a sudden you find yourself in front of a hot bench and they're asking all kinds of questions. And again, you win on the facts and the law, and it's usually the facts. And so it lets associates do, I think, what they do best, which is be the master of the facts. And so, if you can do that and show that you're totally in command and say, oh yeah, there's that email, then there's that email, and there's that email. Oh, and then there was that other meeting that happened. You're going to know that better than the partners on the case are. And they're going to be like, great, you present that to the staff. I'm going to screw it up if I try to do it.
Well, that segues well into one of the topics I wanted to talk about today, which is what associates can do to kind of best add value to an SEC case. Michael, you just talked about like be the master of the facts. And I have always found like, I love a case cron. I love being able to dive into the facts and just like have people make fun of mine because they're like color coordinated and they're hundreds of pages. But at the end of the day, if it's in the case cron, then you use it, at least in civil litigation, for depots, for trial, for everything. And so besides mastering the facts, what is it, Marc and Michael, that an associate can best do when working on an SEC case? And I'll start with you, Marc.
Sure. When I went back into private practice, one of the things that I would encourage the associates I work with to do, or the people who have expressed an interest in SEC enforcement work, is doing the marketing and the writing. And every firm has different opportunities for that. But if there's a new case that just came out, and there's always somebody, as Michael said, there's always an SEC case in the news, and you can get on their tickler, so you get an email every day that the SEC files an enforcement action. You see something new, you do a client alert on it. You do an end of the year report for clients. That was huge. And I think people minimize that because it's not billable work and it's not as sexy as being on a case, but it serves a lot of purposes. Number one is, as a partner, when I wanted to staff a case, and there was some competition, people, once they got wind that SEC enforcement work is really fun, a lot of people would want to get on those cases. And somebody who had come to me and volunteered and written a piece that we could send out to clients, like, well, they're really interested and they know something because they did some research. So it was a good way to get in line to be on the next big case that came in the door. It's also good for professional development. When I assume everybody's got their LinkedIn account, and it gives you something to post for friends and family on your LinkedIn account. Here's an article that I helped put together on this big crypto case that just came out. And you'd be surprised, your old law school classmates and the associates that you started to work with who have gone in-house. It's a nice way of reminding them, oh, you're a securities lawyer, you're an expert on this. And when they need a pitch for a new case, or they just need to talk to somebody, it's a good way to get in the door as an associate. It's very hard as an associate to find those client development opportunities, but having written something that you could then market and put out there, so you're front of mind for people that out in the defense world, in the in-house world. It's great. So I'm a big fan of doing that sort of writing. And then just to reiterate, I can't say enough about how important it is to realize that as much as dealing with concordance or whatever database you're using and managing documents is drudgery, and it's the bane of being a junior litigation associate's life, that's the value you add. And I tell this one horror story. When we were at the SEC, Michael may have been there at the time as well. We had a big case. We were at the end. We were having a meeting with defense counsel, and basically their chance to tell us why we shouldn't sue their client. So they brought it was a New York firm I won't name. They brought the big gun, this famous partner we'd all heard of. He'd represented all these famous people, and he came in and did the pitch, and he didn't know the facts. It was terrible. He's like, these are great people. They didn't break the law. Go away. It was so non-compelling, and we knew every associate in that if he had let them talk, they knew there were holes in it, because we'd been talking to them all along. They're the ones who could, well, what about this email? This is a pretty good defense. Or what about at this meeting where the auditors came in and said, it's okay what you're doing? He didn't have a handle on that. And every time we talked to the rest of the staff without the big guy and the associate would talk, they knew the case, they added value. So you really, being a master of the facts is what, any good partner should be relying on you for.
Yeah, I agree with all of that. The familiarity with the documents and finding the key documents is key. And I would say it is a way to build up a substantive expertise. And I know at our firm, there's a little bit of a, I don't know, tension is not the right word, but should you be a generalist or should you be a specialist? And we have really amazing general commercial litigators. You give them any kind of commercial case and they're going to be off to the races, and they'll learn the particular industry and they're off to the races. And then we have our SEC people, we have our antitrust people, we have our IP people. I'm obviously a specialist. I do one thing. And I think if you are interested in an SEC practice, it doesn't mean that you're committing to be an SEC specialist, but what you can do is develop a little bit of expertise. And that is, as Marc said, keeping up with writing and thinking about it, but also know the elements of the charges that are at issue in your case. I have my prop that I'm always, it's always right here. This is my prop, the federal securities laws. It's always within arm's length. I mean, that's not a joke. Like, that's what you do. And the book is really thick, but there's really only like 4 or 5 statutes that come into play in most cases. And the elements are not that hard. It helps to organize a case by the elements, because that's how you're going back to what I was saying earlier, that's how you're going to kill a case. On the defense side, is you're going to go to the staff and say, you're never going to get there on this element because, the facts are X and you can't prove your elements. And I think that sometimes we dive right into the facts and listen to our clients and they say, well, we did everything wrong. There's sort of an analytical component to, well, wait a minute, what are the potential statutes that could be violated? What are the elements and how are we going to take that down? And that's something I've been doing it for a long, long time. Marc did it for a long, long time, does still doing it for a long time. That's almost like ingrained in our brain. But that's how actually, if you want to add value, if you sort of do that, then all of a sudden we're going to be on the same wavelength without us even necessarily knowing it. And so if you're like, well, I've looked at 10B, and I understand that here are the elements, and how are they going to prove scienter? Then you're thinking like an SEC lawyer all of a sudden, and that's really, I think, can be really, really helpful. Other things I think are just, quite frankly, those of you who are good at PowerPoint, I mean, God bless, that is an important skill. And, we used to joke when I was in the government, like a meeting didn't happen if there wasn't a deck to go along with it. But as it worked out in my career, I sort of pivoted into positions where I was not the person creating the deck, just as sort of people started doing decks. So I have no idea how to use PowerPoint, and I have no intention of teaching myself PowerPoint, because you all are going to be able to do it a lot better. But I think being able to, in all seriousness, being able to convey complex ideas in a PowerPoint format, and that's not just putting a bunch of bullets on a slide deck. That's, sometimes you need to do that, but that doesn't help. It's how do you sort of take a million complex facts and convey it in a graphical way, that can sort of, whether it's a chronology or a flow chart or a diagram, that can be incredibly powerful, particularly for the staff, where again, the advantage on the defense side that you typically have is you have access to all the witnesses and all the facts faster than the staff does. And so if you can get ahead of them on the facts, they are very grateful if you can come in and explain it to them. And as long as you're being straightforward with them, you're not hiding, sort of the, oh, by the way, there's a side letter here, and I'm not going to tell you about it, but you say, well, there is a side letter, but let me tell you why you shouldn't be worried about that side letter. You can get ahead of that, and you can sort of, give the staff the breakdown of a very complex series of facts, and they can be, sort of really grateful for it.
So I want to end with one final question here, and then if anyone has questions in the chat, I would love to hear from you all. You could type it in while we're talking. I want to ask what your favorite cases are that each of you have worked on that you can share. And then also maybe along the same lines, any memorable war stories. And this might be from working on the SEC or working on the other side, but I'd love to hear some of your top stories.
And for me, one of the cases I like to talk about, it was a small case. We did huge cases. We did, Wall Street Journal front page news stories. My favorite was a small one, and partly because I think a lot of people come onto the staff or on the defense side worrying about that big blue book that Michael just showed you, of like, wow, securities law. And I hated securities law in law school. It was my worst grade. It was complicated. And it's good to have a reminder that a lot of it is just, did somebody lie? That's easy. So we had this case. It was involved a guy named Boots, and Boots was a prominent banker, investment banker in Silicon Valley. And one of our examiners, a woman who goes out to brokers and looks at their records just to see everything's above board. Are they keeping things? Are there any problems? She was at a local broker dealer in San Francisco and saw that one of the brokers at the end of each day was emailing his personal email account a copy of account statements from some of their high net worth investors. And she looked further in the records and saw that for a lot of these account statements, there were two different versions, one with that client's name and one with Boots' name. Same document, different name. And what we were able to piece together through the investigation basically was this broker was taking copies of his wealthy clients' account statements that showed all the hundreds of millions of dollars in assets they had in his account. And he would white out their name and put Boots' name on it. And then Boots took all these account statements and he went to the bank to get a loan so he could buy a hockey team. Because if you're a wealthy person in Silicon Valley, you have to own a hockey team. And that was it. That was the scam. He didn't, he basically was sort of bank fraud, but he was using fake account statements that belonged to other people that he put his name on. You don't need to know a lot about the securities law to know that that's probably bad. And once we had a very gifted examiner who went in and she was very smart. She picked up, why would somebody email a document and then there'd be a different version? So she figured this out, and it wasn't that hard to do the investigation. You didn't need to know a whole lot about accounting or securities law to know that this was fraud. And it was sad the guy went to jail, and it was an unfortunate event, but it was a fun little case. It's like, this is pretty old school, just a little white out on a document.
That's great. I don't know. One of my favorite sort of war stories is the day I was sure that I was going to get fired. There were probably a lot of those days, but this one sticks out. We brought a case against some guys up in Oregon who were running these nursing homes. It was essentially a real estate scam. They would buy up these real estate. They would get money from investors, and they would buy up these retirement homes. And the idea from the investment was, okay, you're going to buy a share of, Sunny Endings real estate retirement home in nowhere, Oregon. And what they wwere actually doing is they were pooling all the funds, and instead of being investing in the particular property you thought, they were pooling all the money and they were sort of spreading it around, and all the homes were starting to fail. And so it was a pretty sad situation because you had sort of investor fraud, and then there was a layer of like elder abuse because they weren't running these nursing homes very well. And we went in and we got a TRO or preliminary injunction up in Oregon, and we brought the case in Eugene, Oregon, which is, other than having the University of Oregon, is a pretty remote place. And we brought the case, and it was a whole big to-do. And then we had to go back a week later. And one of the things that's interesting about the way the SEC structures itself is when you're, the job I had when you're a staff attorney, you do the investigations, but when it comes time to litigating, they add on a trial lawyer, somebody who's got a little bit more experience in court, and that's kind of all they do is they litigate, but you sort of live with the case. And so for whatever reason, the trial lawyer on the case couldn't make the next hearing, but it was supposed to be pretty straightforward. So he says, Michael, you go up, you handle this hearing. So I go up, I do the hearing. We had a crazy judge. You go to Eugene, Oregon, which is like I said, it's kind of the middle of nowhere. And there is this gorgeous courthouse, stunning, brand new courthouse. And the judge's first name was also Michael, and they called it the house that Mike built because basically he used his political connections through the Oregon senators to get funds allocated to build this, stunningly huge and gorgeous courthouse for, I think there were 2 Article 3 judges in Eugene. It was like, they had like 7 courtrooms, but 2 judges. And so we have the hearing, and the judge gets a little bit frustrated because we were kind of right, and his buddies in the defense bar were kind of wrong, and it was not looking great for him. So he calls us all back into chambers, and I'm there by myself, and he says, one of the things I like to do, in addition to being an Article 3 judge, is I like to function as a settlement judge. And, I think we can work this out today if you would agree that I can also be your settlement judge. And of course, the defense bar is going, oh, yes, Your Honor, of course, Your Honor. That sounds a great idea, Your Honor. And I'm going, well, what the hell am I going to say? Like, okay, I guess that sounds fine. And he says, okay, well, we're going to hammer out a settlement this afternoon. Well, that's not how it works at the SEC, because I don't have any authority to sign off on a settlement. It actually requires those 5 presidential appointees to sign off on a settlement. Well, I had the temerity to point out to an Article 3 judge that there was actually this executive branch back here, and they had a say over it. And he says, Mr. Liftik, you get on the phone with those commissioners, and if they don't give you the authority you need, I am going to order them to my courthouse in Eugene, Oregon. I was like, oh, that's it. My career is over. Like, this judge is yelling at me, and I'm going to get presidential appointees ordered, and we're going to have a constitutional crisis all over this, little case that we're bringing in Oregon. It worked out okay, but that was one of the sort of fun moments that happened.
Just to jump in a little bit, I mentioned that mine was a small case. The one Michael's talking about was up to the date the largest financial fraud ever filed, not just in Oregon, but I think anywhere outside of California, the Northwest. So again, Michael, as a fairly junior attorney who was on his own in that courtroom, this case was, I don't know, it was $1 billion, but it was hundreds of millions, which is a pretty big fraud for the state of Oregon. So just to put it in perspective, the kind of work that Michael was doing at the time.
So we have 2 questions in the chat, and so I'll have each one of you take one of them. One is from Meredith Mandel, and so maybe Marc, if you want to take this one, and I don't know if you can see it, but she said, you discussed the SEC's problems with ESG rulemaking from any lawyer's standpoint. Is that a growing practice area in our clients? Maybe when you were at Gibson, were clients coming to you asking for help defending ESG lawsuits? And Michael, if you want to weigh in on that one as well, and then we'll go to the next question, then we'll wrap.
Yeah, maybe Michael makes some more sense. I'm wondering if you've heard much, because I'm not seeing a lot of cases. It's not the explosion people anticipated. I think it's more, on the rulemaking side, the regulatory side, preparing for that. But I don't know if you're seeing more of that on the enforcement side.
Yeah, there's not a ton, and there's what you also see is, a case that you didn't even think was an ESG case gets billed as an ESG case because the SEC is trying to show that they are bringing ESG cases. John Quinn has this sort of emerging practice group interest, and so he gets very excited about emerging practices, and ESG certainly was one of them for a while. And we do have some partners, Anthony Alden out in LA, does a lot with ESG, not necessarily in the SEC space, but more generally. And actually, Julianne Hewitt in London actually does a lot of ESG work. So we do have sort of touch points of it, but I agree. I don't think the regulatory work has really necessarily materialized. Where it is showing up on the SEC side is, for example, working with our partner Dabney O'Riordan in LA on the compliance side, helping an investment advisor think through their marketing of a fund. She's done some retroactive reviews for clients where they say, okay, here's our green fund or our ESG fund. Can you look through our marketing materials, look through our PPMs? Do you see any exposure here? And doing that kind of retroactive compliance can be very sort of a way to get a foothold in that area.
And then last, you can both answer this, but I'll start with Michael. Sarah, who is my co-chair in the White Collar Associates group, asked if you have any advice for associates who are interested in getting involved in SEC enforcement, but who might not be headed to the government or haven't decided for sure how they're able to build their practice and expertise in this area within a big firm.
Marc, you want any thoughts?
Yeah, one thing I would say is, I'm a big fan of taking a stint in the government and then taking that back out and using it on behalf of counsel. I lost a lot of associates at Gibson because they saw me saying that, and hopefully they would come back at some point. At the same time, some of the best defense lawyers that we would see at the SEC had never been at the SEC or been in the government, but had been practicing on the defense side throughout their careers and just developed the skills. So I don't want to oversell the importance of going to the government if it's something you're interested in. You can be a very successful SEC enforcement lawyer on the defense side, not having done that. And I think most of it goes back to what Michael said. You get good at it if you've done a few of these cases and you know how to understand the facts and you understand the cause of action. You're able to think strategically. What do we need to prove or disprove? Once you've mastered that, you're pretty good at it. It doesn't take a lot of cases to understand how the SEC works and how the law works. One thing you want to make sure is that you're part of those conversations with the staff, because that is one of the most important things that you see in a good defense lawyer is not just, do you know the facts? Do you understand securities law? But do you know how to work with the SEC staff? And as an associate, if you make sure you're in the room with the partner when he or she is talking with the staff, you see what a good lawyer does to communicate successfully. Because again, some of the worst lawyers we'd see were the ones who came in used to only class action litigation, and they'd be yelling and screaming and fighting and did no favor. They just didn't know how to talk to the SEC. And I think that is a skill you only pick up by seeing other lawyers do it.
Yeah, I agree with that. And to be concrete for Quinn, there's a couple of people that come to mind. Dan Kaufman is a junior partner, just made partner in our white collar group. He never did a stint in the government, and he is a phenomenal criminal defense lawyer. And he just learned it. On our side, Kurt Wolf, who's of counsel, started with us 2-3 years ago. Kurt's amazing. Kurt is one of the best SEC lawyers I've met, and he never worked at the SEC. And the reason he's really good at it, and Marc's exactly right, it's knowing how to talk to the staff and learning that tone. It's a little bit officious. It's a little bit like, oh, of course we want to cooperate, and you're so smart, staff. And you sort of have to learn how to do that in a genuine way while still being an advocate, because you're not going to be as confrontational as you're used to, sort of doing meet and confers and things like that. But really learning what the SEC does and how it works. The SEC is a weird beast, and there's a lot of lingo, and there's a lot of sort of understanding the process. And you can do that on your own. You can sign up for an RSS feed, and you'll see all the SEC cases that come out. Now, it can be overwhelming, but just read the first paragraph. Oh, there's a case about this. I've never heard about that rule. Whatever. I'll go back and read about it another day. The SEC enforcement manual is on the SEC's website. You ever having trouble falling asleep one night? Read the SEC enforcement manual. It'll sort of explain the process to you. And that helps you then start to sort of talk the talk. Know who the commissioners are. Know who the heads of enforcement are. That's all on the website. Just spend some time reading about it if you really want to sort of get into the practice. And that way you're sort of coming at it from a perspective of like, I have a lot to learn, but I think I understand the basics because it is its own little beast.
Well, thank you both for taking the time to join me for our first White Collar Associates event. I think this was really informative and helpful. And luckily we have it recorded if others want to join. So thank you both. And I look forward to hopefully myself now joining the SEC practice group and working with you, Michael.
That's great. Great. Come on in.
Thanks so much for putting this together, Mari. This is great.
Great. Thank you both.